I'm Tim Bartos. This is my guest, Lou Pierro. And I was just getting ready to ask Lou a question. And my first question for Lou is, what are the basic legal documents that everyone needs to protect themselves?
Great question, Tim. When we talk about planning and estate planning, we think about putting in place people to speak for us when we can't speak for ourselves, because for most people, if you're sitting here as we are now, you don't need someone to speak and do finances for you. You do them for yourself. You don't need someone to make healthcare decisions. You do that for yourself. But there comes a time in all of our lives when we can no longer speak for ourselves, and that could be because of an illness, an accident, an injury. It could also be because we've passed on to the next life, and we'll talk about those documents in a bit. But more and more, as people live longer, we have the need for decision makers. And in one case, that is a healthcare decision maker, and the other case, a financial decision maker. So when we look at healthcare proxies and living wills and powers of attorney, those are the documents that we have available to us. And then the cases that have made this resonate with people are not necessarily, as we might think, seniors. Although this is a segment on seniors, the one case in the case of healthcare was the case of the Florida woman who was in a coma for 15 years.
Yeah, and she was younger,
20 years old.
Right, I was just going to say
when she lapsed into the coma.
That's right. I remember that.
And so that case had judges, it had courts, it had Congress convening on a Sunday night. And Terry Schiavo's case is one that most people will recognize the name. And those documents are in place for all clients, regardless of age. People that come into our office in their 20s, people that come in their 80s, get these basic documents: power of attorney, healthcare proxy, living will.
Right.
There's a new one that we'll talk about, disposition of remains appointment. That's after you're gone. And then, of course, a will.
Right. But they're not just for seniors, as you just said.
They are absolutely not for seniors.
Exactly.
And in fact, the first time that most people think about having these kinds of documents in place, especially the will, is when you have your first baby. And we love working with clients at that stage. Young families, they're putting their foundation in place. They now have a child in place. And they want to make sure that if something does happen, that they've taken care of all of those needs.
So that's oftentimes a trigger point for folks to do that. Because I can't tell you how many people have said to me, you know, I really should get a will together. I really should do that. But someday, I just don't have time for that right now. But it's very important to have that document in place.
It is. And when you look at the relative work that's needed and cost that's incurred, and you look at the benefits that are imbued upon your family and your children and your loved ones, it's astronomical how valuable those are compared to what you need to do to get them in place. You just need to do it.
Absolutely, just do it. I think that's Nike that
Somebody
says
has
that, right?
Yeah. We can't trademark that one.
Just do it, at any rate. Let me ask you this, Lou. Is the healthcare proxy the same as a living will? A lot of people think it's one and the same. Is that true?
It is not one and the same.
Not. Okay.
And in New York, in fact, they're very different, because in New York we have a statute that sets forth what a healthcare proxy is, what it does, how it works, and we have no such statute for a living will. And in a proxy, it's just what it says. You're putting someone in place as your proxy to make decisions for you. So as I mentioned earlier, you're appointing an agent, a healthcare agent, who is going to make decisions for you and is going to handle those decisions on your behalf when you can no longer communicate with your healthcare provider.
Sure.
A living will in New York is something that is not statutory. It's been created through evolution of case law. And it simply is a declaration of your intent with regard to life-sustaining treatment at the end of life. So it only deals with a very limited set of circumstances, end-of-life decision-making, and your preferences. The healthcare proxy appoints an agent and deals with healthcare decision-making in a whole host of circumstances. For example, if you have a car accident, you need an emergency surgery. Who are they going to call and talk to about the procedure, about the technicalities, about what kinds of things should be done? And a healthcare proxy appoints an agent to do that. A living will does not. In our office, we only use one document. Some attorneys use both. But what we do is we take the whole concept of end-of-life decision-making and we embody it inside the healthcare proxy. So you appoint your agent, and you provide them with their instructions right inside the same document.
Oh,
and
okay.
We've been doing that for 20 years, and it's worked very well.
Because one of the questions I had for you is, if you have both in place, if you have a living will and you appoint a healthcare proxy, does the healthcare proxy have to follow the living will, or can they change that?
That's a great question. And for since the healthcare proxy law was enacted about 1993, I've debated colleagues in the legal profession over this, because downstate in New York City, many attorneys use two documents. They use a living will and a healthcare proxy, and the healthcare proxy appoints the agent. The living will has the instructional language, and they instruct their clients to deliver the healthcare proxy, but not the living will to the healthcare provider. And they do that because they don't want the healthcare provider to make mistakes interpreting the living will. But for my clients, and I've discussed this with them, their greater concern is that their proxy will not follow their wishes. If you have one document with your instructional language in it versus two documents where the healthcare agent could simply give the proxy and not even give the healthcare provider the living will, then they would not have to follow your wishes. So I think there's a much greater security doing all things in one document, providing the instructions, appointing the agent, and having that document delivered to the hospital or the doctor.
Seems to make sense, absolutely.
Does to me. Not everyone agrees.
I was going to say that not everyone agrees, but it's, I agree with you on that one.